The case is now being recorded. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you, and welcome to the October 4th afternoon Zoom session of the Appeals Court. We're hearing one case today, which is 23P1390, Ships versus Department of Correction. We try to follow the rules on Zoom the same way we do in the courthouse. So it's 15 minutes per side, no rebuttal. There will actually be a little timer will go on, and that where it says Massachusetts Appeals Court, so you can count down the 15 minutes. And when it's not your turn, we ask that you mute your mic, as Attorney Anderson has already done, but stay visible so we can make sure you're hearing everything. And at the same time, try not to make reactions or faces and stuff like that, because that can be distracting. We've read the briefs and materials. We've also read Attorney Anderson's motion. We understand, Mr. Ships, you haven't had an opportunity to respond to that yet, and I think your response is due next week. But I think it's that we will probably be asking questions about that, although not of significantly of a legal nature, more of a factual nature. So with that, the floor is yours, Mr. Ships.
Thank you very much. Good afternoon. As you say, there are two issues on the table today. There is the briefs in principle and the motion to dismiss. With respect to the motion to dismiss, I am preparing my response. I'm a little behind. I've got to the 11th. But as far as today goes, that I lost the feed here. Ooh, I lost my feed.
We can still see you and hear you.
Okay, very good. As far as today goes, the motion to dismiss, it feels to me like another attempt by the DOC to change what's going on here. In the lower court, they argued that this case should be a certiorari or a declaratory. Now up here, they're arguing that it should be moot. And I understand what they're doing. The old adage, when the law is against you, argue the facts. When the facts are against you, argue the law. And when the facts and the law are against you, change the argument. So they're trying to change the argument here to whether this is moot. And just off the top, I am preparing my response. But their primary case that they're relying upon is a case called Pressier versus Newkirk. And it's a U.S. Supreme Court case. And it talks about a prisoner having been transferred and that the case should be moot. In the case of Pressier, the DOC is overlooking the fact that notations were made in Pressier's file, in Newkirk's file, and that's why the court mooted the issue in that particular case.
Can I ask you a factual question, which
Yes.
is, are you coming to us from the Northeast Correctional Center, which is sometimes called the Concord Farm? Is that where you are now?
I'm in Northeast Correctional Center. It's colloquial known as Concord Farm. Yes.
And so, so apparently you had another classification hearing, and they did not use Code R and Code U on you that time.
That is correct. I was transferred to Concord Farm on July 15th of this year. But as far as that goes, I wasn't asking in my petition for contempt for a transfer. I was asking for the DOC to be held to the strictures of Deal versus the Commissioner. Deal 2 is what it is. To the Code R and the Code U overrides that they were using. And I wanted those expunged from my record as they were entered, because I felt they weren't in compliance with Deal. I felt they used criteria and didn't use proper reasoning, and I wanted those expunged from my file.
Mr. Ships, can I ask a question about that? Is there some authority that you can point us to say that expungement is relief that we could grant if we were to agree with you?
Yeah, there is case law on point. Police Commissioner of Boston versus Dorchester Municipal Court. Talks about expungement being a necessary adjunct of judicial authority. And that's backed up by an actual Mass General Law. General Law is 220, Section 2, which governs the powers of the court to issue. And what we're also talking about here is we're talking about relief under contempt. And under contempt, the court has broad authority to issue relief and to formulate relief. But on top of that, there is actually a DOC regulation, and that will be in my response to the motion to dismiss, and that is 120, it's 103 CMR, section 157.13, and that talks about evaluative information and how it's to be corrected. This is important. This is important because these classification reports don't just sit there. The parole board has authority to go and look at these. As a matter of fact, under the parole board regulations, it's information that is considered in making parole decisions. So in this particular case, they have a code U in there. Code U override. And I discuss it in my brief that Code U strikes a black mark against a prisoner as being disruptive and unmanageable and a threat to security. And that's a damning accusation. And the parole board is going to see this when I go back before them. So as of 2 years ago, the DOC was saying that I was unmanageable. And I'd like that to be corrected, and I'd like it to be expunged from my file. So yeah.
So can I ask about that a little? The note that is the implication of their finding. But what the actual language was that you had only just in the last few years begun to acknowledge your crime, and there was also a notation there that you were talking about a co-defendant or a co-venturer who had done one of the murders, which was not. I mean, I think you were not convicted as a co-venturer, right? You were convicted for doing as the principal for both times.
Yes, the Commonwealth's theory of the case hinged on this particular individual, and I was 16 at the time. He was 15 at the time, and the story that he told never put either one of us in the actual house of the victims, but it distanced himself from the offense. He was granted immunity. He initially pled the fifth and refused to cooperate before the grand jury. And so the district attorney's office went and forced immunity and then brought him back. And when he came back, he told his version of events. The case was circumstantial. I accept full responsibility for the death of Esther King and John Lucy. This wouldn't have happened without me. There is no questioning how terrible I feel about what happened, and that it was my fault, whether he was there or not. Now, introducing this new information was what was necessary in order for me to discuss my case.
And if we were to, and the parole board's is gonna know that regardless of whether we expunge that classification for or not.
Yes. But with respect to Code U, it's my contention, and I argue it in the brief, that they shouldn't be using my governing offense, my committed offense, as a Code U override. Code U pertains to your behavior within the.
Cheryl, 117 in the window.
With,
149.
pardon me.
We'll give you another minute or two if you need them just to make up for these.
144, Sinclair. 136,
Thank you. So yeah, what we're talking about is Code U and how it has effects beyond that, and as I was saying, it's limited in its application to behavior while you're incarcerated. My committed offense, and I say this in the brief, it's not a reflection of how I've acted in prison. My prison record is very good. I've submitted some documentation on that. So to say that as of 2 years ago, I was still unmanageable and a risk to the safety and security of a lower security facility is a damning accusation, and it's just simply not true. And it's based in this particular case on my offense from 1982. And I also say in my brief that they are using Code U to circumvent what the court said they couldn't do under Code R. The court gave very specific declarations with regard to Code R. And so now all of a sudden they're using Code U to do what they couldn't do under Code R. And I suggest that the reason that they're using my criminal case to support a Code U is because there was no negative behavior available for them to say he's a problem and we can't send him to lower security. So I'm primarily interested in part of my opposition to dismissal will be this has continuing consequences, and the parole board is going to see them, and it concerns me. My other aspect of dismissal would be they can do this to other people. This is not a class action. I'm not qualified to represent anybody in a class action. But this has continuing consequences for the other juveniles who come to prison behind me. It has continuing consequences, particularly for a little over 200 prisoners who were affected by the recent Mattis-Robinson decision, where 18, 19, and 20-year-olds are being treated as Diachenko juveniles now. There are people coming behind me, and this is going to arise again, and I would like to see the court address it now for a number of reasons, and perhaps to suggest something to a legislature that they need to tighten up 11972B. There are reasons that this case is still alive and should not be dismissed on the grounds of mootness. And as I say, even if it is moot, there are good reasons.
151B, Rosario, 151B.
Can I ask you about if the contempt remedy? I assume you're going to tell me if you do not want another classification hearing at this point. I would take it. I think I would assume you're happy where you are and you don't want them to send you back to Norfolk and do this again, right?
That would be correct.
Are you asking that you're saying that the trial court should fine DOC as for contempt?
Well, contempt would go hand in hand with an expungement order. You really can't order them to expunge it until you find that they have improperly used those code overrides.
So I guess, you're not really concerned with a monetary fine either to the court. What you're concerned with is the state of your 6-part folder.
Yes, I don't think monetary or even costs and fees would be applicable here because it's a suit against the Commonwealth. It's a contempt proceeding, and where the court does have lots of discretion in informing a remedy under Demoulas. Demoulas is a big famous case of mootness and contempt and everything else. It's not really about that. It's at this point, it's about getting that stuff out of my file and getting them to stop doing that to other people, because a decision here will put the DOC on notice that they're not supposed to be using a prisoner's criminal conviction as a Code U override. It's improper. But they also make other allegations in arguments in their brief.
Fisher, 112B, Fisher, 112,
It's a busy day here. So they also talk about how the Code U override wasn't imposed because I was behaving negatively. It was imposed because I was insufficiently positive. There is no such criteria. That's something that they just made up now. There is, the DOC regulations and the classification manuals say nothing about insufficiently positive. It's a made-up criteria that they're trying to sell the court on now. And with respect to Code R, they were saying that Code R was being imposed upon me because I had on and after sentences. And I had pointed out to them a number of juveniles ahead of me who had on and after sentences and multiple cases of murder, who had been sent to minimum, and they hadn't been limited by Code R. But the DOC is arguing to the court now that Code R required that my on and after sentences required that Code R be applied to me, and it's just not true. They're singling me out in that respect, and they're inconsistently applying Code R is what it comes down to there. And my being here now in minimum shows that the idea Code R must be applied because I'm serving multiple sentences is simply not true, because I'm still serving multiple sentences and I'm here now in minimum security. And it's, it feels strange for me to be pointing that out because it's inconsistent with my desire to be here, but yeah. So that's where we stand at this point. The briefs, I think I covered it fairly well in the briefs and in my reply brief. They argued a few things about it having to be willful. The contempt doesn't have to be willful.
If we found that if we concluded otherwise, if we thought that the contempt had to be willful in order for us to grant the relief that you're asking for, what do you point to as the willful conduct?
The willful conduct would be, when they classified me, I submitted a letter in support of that, and I believe it's on page 71 and 72 of the record appendix. And in that letter of support, I highlighted a number of individuals, as I say, who had been sent to minimum under similar circumstances, and that I should be considered and sent to minimum too. But yet they ignored that and imposed the Code R and the Code U on me anyways. That would be willful. And as far as the Code U goes, as I say, I mentioned earlier, and I mentioned in the brief, Code U requires negative behavior. And in that letter, I discussed my behavior while I've been in the department. I've been deeply program involved. I'm a co-founder of the Youthful Offender Coalition, which was started in the wake of Diachenko for the youthful offenders who were being affected by all of these new processes. For several years, for 7 years, I taught I created and I taught the post-conviction relief class for the Norfolk Legal Advisory Committee. I'm deeply program involved, and to say that my conduct is negative enough to impose a Code U override, it's simply not true. And that's why they use my criminal case rather than my actual behavior to impose a Code U override. So I would say that would be willful conduct too.
Thank you. Justice Hannah, that answer your question?
It does. Thank you.
Any other questions from the panel?
No, thank you. No.
Okay, so Mr. Ships, thank you for your argument, and also, your brief is for a pro se brief is pretty well done. So, thank you. And when we do, of course, we'll continue to look at it carefully. So,
thank you, and I will have my response in by the 11th. Thank you.
Okay. Thank you. And so, so if you wouldn't mind putting yourself on mute, and then so we don't have to hear those announcements. Very good. Thank you. Good. And Attorney Anderson.
Good afternoon. May it please the court and Mr. Ships, Charles Anderson on behalf of the defendants.
And we've got the note. Do we have the notice thing figured out at this point? Are you getting our notices now at the right email address?
Correct. Yes, the email is no longer going to Charlie Anderson. Thank you. The court should affirm the trial court's decision because Mr. Ships hasn't proven by clear and convincing evidence that the defendant should be in contempt, and that they demonstrated clear and undoubted disobedience to a clear and unequivocal command of the court, and for the reasons contained, in the trial court's judgment and in our brief, this court should affirm the trial court's decision. I'd like to address a couple of the contentions that Mr. Ships has made an argument. He contends that other incarcerated individuals who had similar circumstances to his crime were not imposed Code R. And what that actually does is demonstrate that the commissioner's designee made an individualized decision as to Mr. Ships, and it wasn't based necessarily on his offense.
Where do we get that information, Attorney Anderson? Where do we see that comparison taking place? Some indication that there was a specific comparison of Mr. Ships's case against other similarly situated juveniles.
In the rationale, it talks about the facts of the offense. It does not, and I'm not sure how it could compare to identifiable individuals' crimes. It does talk about the aspects of the offense. And bear in mind that these decisions talk about the seriousness from a classification perspective, from a perspective of evaluating an incarcerated individual's suitability for minimum security. Now, what Mr. Ships talks about is basically asking the court to reweigh all the factors that go into the commissioner's designee's decision. Things that are not in dispute are that Mr. Ships has been involved in a vast amount of programming. That is cited by the Assistant Deputy Commissioner in her decision. It's also not in dispute that he has behaved well for a period of time. While these two criteria are necessary for an incarcerated individual to be considered for minimum security, they are not sufficient. And what needs to be sufficient is what Mr. Ships was able to demonstrate in 2024 that he couldn't in 2022, is knowledge of his crimes, the responsibility that he has for those crimes, that he has addressed the causal factors of those crimes, and he's done so in a way sufficient enough for him to be held in an unwalled facility, minimum security, for an indeterminate period of time. The Department of Correction has a very high standard for this. And
Can I direct you back to back to Justice Hand's question? In the Mr. Ships' argument is that he said there that you in the Code R, it said it describes the facts of his crime, and it's not pretty, but he lists there are 6 or 7 or 8 other people with just as bad crimes or maybe worse crimes who did get who Code R was not used on. So I mean, how do we know, where's the comparison between you're supposed the deal 2 said that the rationale has explained why his conduct is different from others, and I mean the judge found it was implicit or something like that. But I mean, but how do we know that that type of analysis was done?
it doesn't specifically state in the rationale how Mr. Shipp's crime compares with others in terms of the facts of their crimes versus his. What's missing from the comparison is what level of acknowledgement and responsibility one has taken for their crimes and have been able to address the facets of their particular crime through program.
That was the rationale used for the Code U, right?
It is used for Code U, but you'll also see in the decision on page 97 is that these codes are used in conjunction with each other, because when you have crimes that are very serious from a classification perspective, that is here that they go beyond the scored offense, which was one of the murders, is that the person who committed those crimes has to be able to show that they have addressed the causal factors of the crimes that they have committed, not just the single murder, but in Mr. Shipp's case, the second murder, the 2 armed robberies and the 2 armed assaults in a dwelling. He has to be able to demonstrate that he has addressed the causal factors of those crimes through programming, and is able to demonstrate insight sufficient enough that he no longer presents a risk to being held in a minimum security facility for an indeterminate period of time. You'll note at the bottom of the decision by ADC Nelligan page 97 of the record appendix, is the applicability of Code R coupled with Code U demonstrates that his placement in lower security at this time would pose a risk to it, and that a longer period of positive adjustment to include continued program participation is necessary in order to ensure that he has acquired and internalized the skills needed to be safely housed in minimum security. It's what it comes back to, and this is more in the discussion of Code U, is that this challenge classification proceeding, despite decades of classification proceedings Mr. Ships has had, is only the second time that he has talked about his crime to the classification board. So up to that point, they can't even determine whether or not he has begun to address the causative factors of his crime. They know that he has been in programming. They know that he has completed a lot of programming.
How do you address how do you respond to his argument that what you're saying is that he's been insufficiently positive as opposed to having negative conduct?
As I said before, participation in programming and a continued period of time of good behavior is necessary for somebody to be transferred to minimum security, but is not sufficient. Going back to Code U is very clear that it says those inmates whose behavior may serve to threaten security or undermine the exercise of proper control and maintenance of order, while the clause contained in between says not always negative enough so as to warrant disciplinary action. The actual language of the override does not require negative behavior. What it requires is that their behavior may serve to threaten security at lower security. And here, what we have here is up until the classification proceeding before this challenged one, Mr. Ships didn't even talk about his crimes. He wouldn't talk about his crimes to the classification board. This is borne out not only in ADC Nelligan's decision, but also in the minority board recommendation vote, is that he needs a longer period of time of discussing his crimes and his responsibility for those crimes in order to have demonstrated to the classification board and to the commissioner's designee that he has shown the insight needed in order to be transferred to minimum security.
Can we turn to your the mootness argument? And could you respond to his argument that there are continuing consequences of this classification report?
I think those arguments are speculative at best. When we're talking about Mr. Ships, who's been seen by a classification board at least once a year over the past 40 years, that there was a Code U employed against him in 2022, and he's at minimum security now. Really, I think this is pure speculation on the part of Mr. Ships, and it also evidences a misunderstanding of what Code U actually states. There's nothing in there about being a management problem. What it is in there is that he is not suitable for minimum security at that time. That is what the code says. Since then, he has demonstrated himself to become suitable for minimum security, and that's why the decision was made. In terms of the mootness argument, this really goes back to what's been filed in this case. This was filed as a complaint for contempt under 231A, section 5. Contempt is usually considered something coercive. It looks forward to using the coercive powers of the court to conform behavior to the order of the court. What Mr. Ships is asking for here is for the court to look backwards to 2022 to evaluate that classification report in a vacuum, and somehow arrive to the point that this 2022 classification report has had more of an impact on his potential parole suitability than his current classification report.
I mean, I thought he wouldn't get that relief unless we were also to determine that the department wasn't, that its actions warranted a sanction of contempt. So we'd have to be fine that the department was not correctly utilizing code R and U under deal. And
I would question, sorry.
Yeah, no, go ahead.
I would question at that point that even if the court found the Department of Correction in contempt for that, what is the next step there? Because ordinarily respect for another branch of government, would be that if this decision did not clearly articulate what's required under Deal 2, normally the deputy commissioner would be given the opportunity to correct that. An agency would be given the opportunity to correct that. The idea that because this decision somehow demonstrates clear and clear and undoubted disobedience to a clear and unequivocal order of the court, that the next step is automatically expungement from his record, and basically stating that in 2022, Mr. Ships was seen by a 3-person classification board. Two voted for him to go to minimum security. One said that he should stay because he didn't discuss his crime. That nothing else happened on that classification report. I mean, this is of concern because DOC's classification regulation does not provide for expungement, in contrast to the disciplinary regulation. And also the policy cited by Mr. Ships, while I hope I get the opportunity to reply in writing, the evaluative information policy talks about in terms of what a person can do to make sure that their record is correct, that their department record contains correct facts. What we have here is Mr. Ships disagreeing with the decision and asking the court to reweigh the factors which the commissioner's designee has already weighed and make a decision in his favor and order us to the Department of Correction to expunge a classification decision. This is unprecedented.
But I'd like to ask you to supplement the record, to supplement your motion to dismiss with the classification report in which he was transferred, I think that would be helpful. That would be helpful to the court.
Absolutely.
And also if you feel the need to respond to his opposition to your motion, file, I'm sure you would file a motion for, leave to respond and in a very short time period.
Certainly. And outside of what's already been discussed, I just wanted to quickly mention a couple of items that were brought up in the reply brief. Mr. Ships talks about his COMPASS score. The COMPASS score is ordinarily administered to incarcerated individuals at the beginning of their incarceration, and it's used to develop their personalized program plan. It's not used for inmate classification. You'll notice in his classification report, there's no reference to his COMPASS score whatsoever. You also notice in, I believe it's page 79 of the record appendix, that Mr. Ships, when he was administered his COMPASS assessment, was in 2014 after the Chenko case, which made his non-parolable life sentences parolable, and then he was provided a COMPASS assessment at that point, put him as low risk of violence, low risk of recidivism, and low risk of drug use. Those are far from the only factors that the Department of Correction considers when determining someone is eligible for a particular security level. And as I said, you look at his classification report, it does not reference his COMPASS.
What is on our record appendix 91 there is a score which it's a Reese classification score. What do you call that? What's the term for that?
Sure, that's called the point-based score. That is the score.
Point-based? Yes,
it's the full name is the objective point-based score. It's called the OBPS or PBS. This is the score that is calculated each and every time an incarcerated individual has a classification hearing. And this score, what it does is, as also stated in Deal 1, is it determines what classification level a person is being considered for. So this starts the process, the calculation of the score. And these overrides that we talk about are overrides for what the classification score shows that the security level they're eligible for. In Mr. Ships' case in 2022, he scored a 2, which would consider somebody for minimum security classification, but the commissioner's designee used overrides to the classification score, and she explained those overrides on page 97. So unless the court has further questions, the defendants rely on their brief and whatever supplementary material can be provided to the court following Mr. Ship's opposition to the motion to dismiss.
Yeah, my colleagues, and I don't see anybody raising their hand to ask a question. So I think, no, we understand both of your arguments, very well briefed on both sides, and the case will be submitted. So we'll log off, and both of you have a good weekend. Enjoy
you.
this nice weather.
Thank you, Mr. Ships.